Hi guys, welcome back to Battle with Ola. This is Mujala Olua and I'm so thrilled to have you here once again. Today we want to talk about pleadings. Pleadings is a very important topic in Nigerian law, especially for law school students, and it's very important for lawyers also, especially litigation lawyers, because it's the fulcrum upon which civil litigation is based. And so if you are an intending litigant as well, you would find this topic very useful too. Let's talk about pleadings in this video. Don't forget to like this video and don't forget to subscribe to the channel, and by all means share the video. Let's talk about pleadings today. Pleadings are written statements or allegations made by parties in a lawsuit, setting out material facts upon which their claim or their defense is based. Yeah, so if you want to file, for instance, for recovery of land now, you are the claimant, you're going to come by writ of summons, quite all right, and then you're going to attach a statement of claim. What your statement of claim contains is what we refer to as pleadings. If you are the defendant and you're going to reply to the claim by filing a defense, your statement of defense is also a type of pleading, or pleadings. So what we actually mean by pleadings are, the material facts that actually make up your case. What you're telling the court that this and this and this and this are what happened in this matter, which led to this dispute, which gives me a basis for asking for this, or for asking or praying the court to give me this, or command the other party to do this, or refrain from doing this. So that's what we mean by pleadings. It's very simple. The types of pleadings we have: the statement of claim, the statement of defense, there's a counterclaim, there's set-off. Counterclaim and set-off are similar, but they're not the same. And there's reply, and then we have further and better particulars. Those are the 5 types, or maybe 6 types of pleadings that we have in Nigeria, and we're going to look at them just briefly, but I hope that you'll be able to get a hang of it. What's a statement of claim? A statement of claim is a set of facts that you put before the court, telling the story of how the dispute actually originated, which just led you to the point of coming to court to ask the court for something or for some things. Statement of defense. Statement of defense is a set of material facts that you put before the court, denying the claims of the claimant in their statement of claim, and then telling the court your own side of the story, and which has now led you to the point of asking the court not to grant what the claimant is asking. And then we have counterclaim. I've been very careful not to include what you want from the court, in the statement of defense, because it can now flow into counterclaim. Counterclaim is a way by which, if you're a defendant in a matter, someone has sued you to court, they filed their own pleadings by way of statement of claim, and then you have filed your own defense. So in denying what they have accused you of or told the court is the situation of things, when you now ask the court for some things, based on how you have denied the matter, you are now also asking the court for some things, then we can say that you're counterclaiming. So it means that you're not the original person that brought the matter to court, but when the person that brought you, you not only came to defend yourself and deny what they have put to you, but you are then also asking some things from court as if you were the claimant. So you are like a special type of claimant, but you're counterclaiming because someone claimed first. Now you are claiming some things because you are defending what they have claimed, and then you're not asking for some other things. So counterclaim, yes. And then we have set-off. Set-off is the means by which you counterclaim for a monetary sum. So let's say the claimant has asked the court for to command you to pay them 15 million naira, and you also have a counterclaim. Maybe the claimant is owing you. You have a cause of action against them that they are actually owing you 10 million naira. You come by way of set-off, asking the court, counterclaiming that 10 million naira. So it's not a counterclaim strictly sensu. It's different in the sense that you're asking the court to set off your own 10 million naira from the 15 million that they are accusing you of owing them, for instance. And then so if the court makes a decision, what will happen is that they will deduct that 10 million naira from their 15 million, and then you have to just pay them 5 million naira. So that's what a set-off is. Please don't hesitate to read up more on some of these things, you know. And if you're a lawyer and you are well versed in civil litigation, you would already understand what I'm talking about too. But I don't want this video to be so lengthy, so that you can keep your attention, you know, and so that, you know, we can move forward very fast. So that's a set-off. And then we have further and better particulars. Further and better particulars are usually used by the defendant, although they can be used by either of the parties. So if someone has filed a statement of claim and you consider it very vague, you know, and, you know, just all over the place, not really specific, you can file a further and better particulars as the defendant to clarify the issues and tie, you know, the claims, to tie the issues, you know, the real issues that the court should decide upon, to narrow them down to specifics. So you can file a further and better particular to shed more light on the vague issues or the vague pleadings of the claimant or of the party that you're filing against, and then to narrow down the issues to specifics. You file a further and better particular. You file further and better particulars. And of course, the last one is a reply. A reply is a further, you know, response by the claimant. When you file the statement of claim and the defendant has filed their defense, and you have further things to say to them, or as an answer to their defense, you can file a reply. And usually replies are on point of law. So you cannot really come and start raising new issues or still arguing facts in a reply, usually in a reply. And now when we're talking about reply, we're not talking about reply to petition in a matrimonial cause. If you have watched the video on divorce, you would understand what I'm talking about. Please do if you haven't. But we're talking about a reply whereby you're answering the defendant's statement of defense, but on point of law, just before the court you know, decides on the issues. So that's what a reply is. So I've talked about statement of claim, statement of defense, further and better particulars. I've talked about counterclaim, and I've talked about a reply. Also, for a counterclaim can stand or can constitute, you know, a new cause of action, an independent cause of action. So it's very important for you not to take any chances. So if you have filed a statement of claim, the defendant has filed a statement of defense, and they have filed a counterclaim. Don't forget that counterclaim is their own claim against you. So if their defense to your claim, even if it doesn't hold, and maybe both of them cross each other out, their counterclaim can stand alone and can be decided upon by the court. So even if you win them in their defense, they can also win you in their counterclaim. So don't go to sleep. If you have a response to their counterclaim, don't hesitate to file a response to the counterclaim. If you do have a response, okay? It doesn't mean that you have to respond to every pleadings filed by the other party. It just means that when you filed something and the other party has filed something else, if you deduce or surmise that maybe what they have now filed, you know, what you have filed will no longer be sufficient as an answer, or, you know, as in crossing out what they have filed or the response they have given to your statement or to your pleadings, please file something else. File something in response, something that addresses it, and you already know what you can file. So also, the difference between a set-off and a counterclaim, one major difference is that a set-off is tied to the plaintiff's claim or the claimant's claim. A set-off is also different from a counterclaim in that set-off is monetary, counterclaim need not be monetary, and then set-off is tied to the plaintiff's claim, like I've explained. But a counterclaim can stand alone. It can constitute a totally different course of action, so it can stand on its own. Yes, and if a set-off does not disclose new facts, you need not traverse it as a plaintiff, but it is important for you to respond to a counterclaim except you are admitting it. It's very important for you to respond to it. So that is all about that. Now, it's important to say that a writ of summons is not a type of pleadings, but it can be read together with your pleadings. You know that when you're filing an action in Nigerian court, civil matters, whether it's at the NIC or it's at the High Court, or Federal High Court, as it were, you'd file a writ of summons or an originating summons, or whatever the originating process is, and then you attach your statement of claim to it, and then you attach the other documents that are necessary, a list of witnesses, and other things. But a writ of summons on its own is not part of pleadings. But when it's read alongside your statement of claim, all of them together combined, you can call them, both of them combined together can be called pleadings. Yeah. But whatever you ask in your writ of summons, if you do not set it out, as a material fact, or plead it, that's how we say it. If you don't plead it in your statement of claim, it is deemed abandoned. Now let's talk about the functions of pleadings. What do pleadings do? The first thing is that pleadings is the way by which you set out, the facts in the case, the fact of the matter, what the case is really about. You set it out by way of pleadings. So pleadings is the way by which you bring to the notice of the court the material facts in the matter or in the dispute. That's one. The second thing is that it is the way by which you notify the other party of what to expect. That is, you inform them of why you are in court, your grievance against them, what they are to expect. So it helps them to prepare their own response, to your pleadings. And of course, pleadings will show who the burden of proof is upon, or in a matter. So pleadings will help give direction to the case in general, to help us to know who is claiming. He who asserts must prove. So who is asserting this? You're asserting in your pleadings, you're setting out facts. So we know that if you are the one that has asserted this, you have to prove it. One very key fact that you must never forget is that when it comes to trial, of the actual trial of the case, whatever you have pleaded must be led in evidence. So if you have said that on the 28th of August 2022, the defendant hit you, the claimant, with his car, by the time you put the claimant in the box as a lawyer, he must talk about being hit by the defendant's car or being hit with a car by the defendant. You must lead evidence, ask questions that will make him say that to the court. Because, of course, that we front load our originating processes in Nigeria. Front loading just means that we file all our processes, everything we want to talk about, and the documents and all of that we want to refer to during the trial. I've done a video on examination, cross-examination, and re-examination. So that's trial. You need to watch it, please do. So whatever it is that you intend to talk about during trial, that you want your witness to talk about, that you want your claimant, your defendant to refer to, must be pleaded or pled. Is it plead or pleaded? It must be pleaded or it must be pled, in your statement of claim or statement of defense or whatever it is, the document that you're filing. Now, when you now put that witness in the box, they must talk about those things. You must not say that, oh, I filed it already. The court can refer to it, because the other party will, in their written address, talk about it. Whatever you plead and you don't make reference to or lead evidence upon is deemed abandoned. So if you don't lead your witness to talk about how the defendant hit them with the car, like I said, it will be deemed abandoned. So if, for instance, you're claiming, damages, for the injury done, maybe hospital bill and what have you, by the time you get to that point, when the defendant is writing their own written address, they will remind the court that you didn't make any mention of it during trial. So it's deemed as if you have abandoned that particular fact, which means that you have not given the court sufficient reason to award the damages or to award you, the recompense for, the damage, the injury that you suffered. There's a difference between damage and damages now. Damage is the injury that is done to an injured party in a dispute. Damages is the monetary claim that you are asking for as an injured party for the damage done to you. So there are two things, damage and damages. So those are important things that you should note about pleadings. Now, what do pleadings contain? I know that you should have an idea by now, going by the fact that we've talked about the documents, that are considered as pleadings. But let's just go over it again. Pleadings contain material facts. Material facts. You know what facts are. Facts are different from opinion. Facts are different from law. Facts are different from, suggestions, insinuations, perceptions. Facts, things that actually happened, material facts. pleadings must contain material facts at all times. Pleadings must not contain evidence, but they must contain facts by which they must contain the facts upon which you intend to tender evidence. What do I mean? That is, if you want to show the court that somebody was harmed now, and you have a picture to show that they were harmed, the picture does not go into your pleadings. You just tell the court that they were actually harmed by so and so. So in trial, when you're leading them to talk about how they were harmed, you can then tender evidence, tender the photo in support of the fact that they were actually harmed. But you don't talk about a photo or add the photo to your pleadings. Pleadings do not talk about evidence, but they talk about the facts which the evidence supports. Pleadings do not talk about evidence, but they talk about the facts which the evidence supports. You don't plead law. You don't plead law in pleadings. You don't plead law. You don't plead conclusions. You don't plead, legal arguments in pleadings. Except, of course, it's a reply on point of law. That's different. But normally, pleadings are not supposed to contain law, legal arguments, or legal conclusions. No. Leave that for the courts to decide, and leave that, for your meeting address. Now, pleadings, the facts contained in pleadings must be stated precisely. No room for randomizing, no room for circumlocution. The facts must be stated precisely and positively, okay? And of course, pleadings must contain the relief sought and the prayers. So when you have talked about how, for instance, if it's unlawful dismissal, your pleadings, what you do is you introduce the company, you introduce the claimant, the defendants, who they are, facts about who they are. Facts about who they are. Oh, the claimant is Mr. So. The defendant is so Nigeria Limited. The first defendant. Now, the second defendant is the managing director of so Nigeria Limited, managing director of the first defendant, for instance. Then you talk about how the claimant, Mr. So, was employed on the day of dash year, and how he was employed into this particular role. Then he worked for a certain number of period of time. Then he didn't get a query, or maybe he got a query, and this is what happened. And then on one fateful day, on one fateful day, he just received a sack letter. Maybe if there are things that have gone on that led up to the sack, you talk about it. Then you talk about how then this is how his employment letter stipulates that he be dismissed. Or if it's an employment with statutory flavor, this is how it should be dismissed under the so act or so law. But that was not done. And then what are you asking the court to do? To declare his dismissal as unlawful. You are asking for his unpaid salaries in the sum of so. You are asking for damages. What type of damages? Special damages, general damages. You're asking for special damages, general damages. There are different types of damages. You ask for it, and then you conclude. So your pleadings must contain not just the material facts, but the prayers that you're making to the court. If you're asking for a declaratory order, you put it there. If you're asking for monetary damages, you put it there, and you put everything you want from the court there. So those are the contents of your pleadings, what they should contain and what they should not contain. So let's talk about the structure of pleadings. You know that I always like to talk about the draft itself in when we're talking about litigation matters, or when we talk about, whenever we're talking about anything that has to do with documents, on this channel. So how do you know what's the structure of a pleading? Let's say a statement of claim, for instance, or a statement of defense or counterclaim, what have you. What does it look like? You have the heading of the court in the High Court of Justice, Lagos State, in the Ikeja Judicial Division, holding at Ikeja. That's the heading of the court. Then you have the suit number. When you're filing, you wouldn't have been given a suit number, but you just put a space for suit number. So by the time you file, the registrar will write the suit number there for you. And then you have parties. You have between Mr. So and as the claimant, and so as the defendant. Then you have the heading, statement of claim, statement of defense, reply on point of law, further and better particulars, statement of defense and counterclaim. or counterclaim, as the case may be. That's the heading. Then you now begin to set out the facts in chronological order, in the order in which the events occurred. For instance, you tell a story. That's how it is. Tell a story. So make sure that the person is following from the origins, of the relations of the claimant and the defendant as pertaining to the suit or the dispute, up until the point of the dispute, and then the result of the dispute, and then what you're asking the court for. So tell a story and let it be chronological in order. And then you date it. Pleadings must be dated. You date it, and then you sign as the lawyer, or you have the claimant or the defendant sign, if as the case may be. So either your signature or the defendant's signature or the claimant's signature or the litigant's signature or the lawyer's signature. And then you have the address for service on the other party, maybe the defendant. You put their name, their office address, their phone number or email address if you have it, address for service. So that is what the structure of the pleadings. So usually pleadings are written in chronological order. I've said that. So, and then you number it. You number the paragraphs. So they're written in paragraphs. You number it. The claimant is Mr. So. That's 1. 2. The defendant is Mr. So, or the defendant is Kiniko Nigeria Limited. 2. Now, the second defendant is managing director of first defendant. That's 3. The first defendant is a limited liability company located at number so. So you start to list out in chronological order and you number it. That's 1. Number 2 is that when you're using when you're talking about numbers or dates or figures in pleadings, they are to be written, in figures and not in words. So if you want to write 4, you write 4, not FOUR, for instance. And then the nomenclature has to be consistent, So the reason why you're introducing people or parties as first defendant, second defendant, or claimant is that after that you will be referring to them as claimant. Oh, the claimant went to his company on so date. When the claimant entered his office, he sat down. The claimant then sent for his managing director. The claimant then picked up the telephone and called his colleague. Like that. The defendant entered the claimant's office. So you will not be saying Mr. Lagbaja or Mrs. Lagbaja. The nomenclatures must be consistent. If you're talking about, a sale of land, for instance, and you're talking about a deed of conveyance, you cannot, in another place now, talk about agreement papers. If you have used deed of conveyance to talk about the document that was executed when the land was sold, you have to continue to use deed of conveyance throughout the pleadings. So very important, nomenclature must be consistent. So because we're telling the judge a story for the first time, it's important for you to be clear for him to understand. He has a lot of things to read. If your pleadings are not clear enough, it sets you off on the wrong foot from start. So it's very important not to shoot yourself in the leg. Whatever party you are, make sure that your pleadings are very clear and unequivocal. Very important. There are so many things that must be pleaded, as a matter of compulsion. Some things must be pled or pleaded. If you don't plead them, and then you get to court and start talking about them, it might not work out well for you. So very important. For instance, the general rule is that any fact that will take the other party by surprise must be pled or must be pleaded. Any fact that will take the other party by surprise must be pleaded. Pleadings gives room for the other party to adequately prepare their defense so that the court will not be going on a wild goose chase in deciding the matter. It's important for you to plead any fact. It's important to plead any fact that will take the other party by surprise. So a few things that you should plead as a matter of compulsion. Number 1, if you are alleging a crime or fraud, you have to plead it. If you are alleging any form of illegality, it must be pleaded. That's 1. 2, if you're saying that a document is unenforceable, it must be pleaded. Very important. 3, if you are claiming statute of limitation, it must be pleaded. you must call the court's attention to it in your pleadings, because statute of limitation is already established in law. So it's a fact that if a matter is statute barred already, it cannot, be litigated upon. So if you want to refer to or rely on statute of limitation, you must plead it. Very important. You must plead equitable defenses that you intend to rely upon. Maybe laches and acquiescence, undue influence. Any, equitable defense that you're relying upon must be pleaded. I've done a video on laches and acquiescence, so please watch it. If you're pleading if you're relying on estoppel, we should do a video on estoppel. I will do it by God's grace. So if you're relying on estoppel, you must plead it. Very important. If you're relying on res ipsa loquitur, you must plead it. Res ipsa loquitur is some sort of plea, so if you're relying on it, it must be pleaded. If you want to rely on a family or traditional history or titles, in a land dispute, for instance, if you're planning to rely on traditional history or titles, family history, as proof of ownership of land, as a defendant or as a claimant, you have to plead the names and titles that you want to refer to. You have to plead all those things. The names of the ancestors that you want to talk about, that you want to rely upon as, the owners of the land. You have to plead their names, their titles. You have to plead it. Or even in chieftaincy matters, if you're relying on particular titles or historical stools or what have you, you have to plead those particular names and titles. Very important. If it's a libel case, you have to plead the actual libel. The words that were used must be set out. So if where the libelous words is you are a coconut head, for instance, you don't come to court and just say that, oh, he said so. He said so against me. He wrote it, he printed it. No. What are the words, the particular words that were used? You are a coconut head. We must see it in your pleadings. Very important. So when I'm saying that you must plead it, you must plead it. What I just mean is that you must set it out. You must type it into your statement of claim or statement of defense or whatever type of pleadings it is. You must put it there, write it there. What all these things that you intend to rely upon at trial or improve or in support of your case. You must plead them, means you must put them in your process, in your documents that you are front loading to the court. So if you are claiming a defense, for instance, in a defamation suit, if you are claiming justification or fair comment, for instance, you must also plead it. You must put it down. Don't say that when I get to court, that's when I will now mention it. It must be in your pleadings. And then when you now get to court and mention it, it will be backed up by your pleadings, and then you would have the case before the court. So if it's a contractual matter, you must plead the actual breach of the contract. For instance, if it's a breach of contract matter, you have to plead the fundamental breach, that particular act that was done, the term of the contract that was breached. You have to plead it. You have to make reference to it, state it out that, okay, section so of the contract states that so, and this person did this or did not do that, and that's in breach of this section of the contract. You have to plead that. Very important. If you're alleging adultery, for instance, you have to plead the dates and times of the alleged acts of adultery. So on the 10th of July 2022, the claimant caught the defendant in a hotel with another man. Let's say the defendant is the claimant's wife. You already know what type of matter that is. So you have to plead, that is, you have to talk about the acts of adultery, when they happened, the date and the places where they happened. You have to talk about that. Foreign law, customary law, those must be pled particularly. Except, of course, it's a customary law that's been taken judicial notice of. But if not, you have to plead them. If you are an innocent third-party purchaser, a purchaser for value without notice, you have to plead that particular fact, that you're a purchaser for value without notice. So in this matter, you must plead that fact before the court. Don't assume that from the story you've told, the court will just, make that conclusion for you. No, you have to plead it specifically. Any defense of maybe insanity, intoxication must be pleaded. Set-off, if it's a set-off, you have to plead the set-off. And if you're asking for any type of damages, any monetary sum, you have to plead it. You have to mention it and show proof as to why the court should grant that to you. Very important. So if, for instance, like I made an example, you want to talk about our hospital bills, you have to plead the fact that the defendant went to so hospital and incurred a bill of so, you know, and so that's why you're asking for the sum of so as so damage, you know, because of the injury caused. So you can't just say, oh, the defendant was injured, so we're asking for 15 million naira. Why? Did he go to an hospital? Was he treated? Did he incur any bill? So you have to plead all those things. So this is a fair list of things that must necessarily be pleaded. But what this gives you an idea of is the fact that whatever it is you want to claim before the court, you have to tell a story that supports it and show cause as to why the court should agree with you. And of course, you know, explain everything clearly and unequivocally. That's the essence of pleadings. So there are specific time frames within which you can file, you know, pleadings. So if you're going to any court, you want to file for the first time, or you want to respond to something that's been filed against you, as a lawyer, the important thing for you to do is to go get the rules of court. They will tell you the time frame you have. For instance, in Lagos, when a statement of claim has been filed against you as the defendant, as soon as you've been served, you have 42 days within which you can respond. That is, file your own defense. In Abuja, it's 14 days. So you should get the rules of court, of whatever court where you have been sued to, you know, if something has been filed against you, so that you know the time frame that you have. 42 days in Lagos, for instance, for you to file your defense, and 14 days in Abuja. Now, aside that, the court will grant an extension if you run out of time. But that is not for you to now go to sleep and think that you can always file for an extension. But if you run out of time, you know, you can always make an application or notice and serve the other party, asking the court for extension of time within which, you know, to file your process. And of course, you have to pay the default fees. You know, there's penalty for each day of you not filing what you're supposed to file. So even when the court grants you an extension, you have to pay penalty fees, you know, filing fees, penalty filing fees. You have to pay that. Now, there's something called default of pleadings. That means that you have filed a process and the other party has not filed what they're supposed to file in response to your process, and, you know, time has gone. So the time has elapsed and they are nowhere to be found. They have not shown up. They have not filed anything. So you can apply for judgment in default of pleadings. But even when you apply for judgment in default of pleadings, in most cases, you still have to prove your case. It doesn't mean that the court will grant you judgment straight away. It means that, for instance, if it's a monetary claim, you have to prove to the court why the court should award that sum against the defendant. Yeah. So if it's you are proving ownership to land, if you are claiming ownership to land now, for instance, you have to prove to the court, to the satisfaction of the court, that you're actually the owner of the land. So the court will not just grant you judgment because you came, you asked for it, and the other party did not show up. And of course, also, if you are the other party and you have not shown up for any reason whatsoever, it better be a good reason. Because judgment in default of pleadings can be set aside if you make an application to the court. But you know, it's not just free. You go through some certain rigors. But I'm just saying that if you're the one that filed, that took a matter to court, you're expecting a response and the other party did not respond, you can always file for judgment in default of pleadings. So pleadings will not end in perpetuity. That means that pleadings will not go on and on and on and on. It doesn't mean that you file a statement of claim, the other party will file defense, you file reply, they will file further and better particulars, and you keep filing and filing. No. Pleadings will end at some point. So at what point can we say that pleadings have been closed? Pleadings usually are closed when parties join issues. And when can we say parties have joined issues? When both parties have exchanged processes, the necessary processes. For instance, if you file a statement of claim and the other party has filed a statement of defense, whether they counterclaim or not, they filed a statement of defense, you know, denying the things that you said, or maybe even counterclaiming for some other things. We can say that you have joined issues because you've exchanged, you know, processes. So pleadings are closed. But by leave of court, and then there's a time frame set aside for any other party, for any party to file any other thing. So when that time has elapsed, we say that pleadings have been closed, except by leave of court. So if a party has any other thing to file, you know, they can come by leave of court, make an application to the court to allow them file that thing outside of the time frame for which they were within which they were supposed to have filed it, and then they can file. Aside that, pleadings close when parties have joined issues. Pleadings close. Can you amend your pleadings after you file them? Yes, if you omitted something or you made a mistake, or you want to add anything. Not that you want to bring a totally new set of pleadings, but you want to make an amendment. A crucial amendment. You can file for an amendment. And how do you do that? You come by way of an application, a motion supported with an affidavit, explaining to the court what you want to amend, why you want to amend it, and why it is crucial for the court to grant you that amendment. So when the court has granted that order, you can then file your amended pleadings, which will now substitute the ones that you filed before, whether a statement of claim or statement of defense or whatever. So you can amend. Maybe you want to do change of name. Maybe a party has died, you want to substitute them, or you want to, strike off their name, or maybe you made a mistake as to a date, or as to some facts, or maybe even the matter is already going on, but you want to make an amendment that is crucial to justice being done in the matter. You can make an application for amendment. The court will grant it as long as it's not frivolous, it's not wasting the time of the court, as long as it is not changing the nature, the original nature of the matter, and it's not disclosing an entirely new course of action. And as long as, if a trial has already begun, if the evidence that's been laid, is in support of what you want to add, the court will grant you, leeway to add or subtract whatever it is you want to amend. Very important. Even at the Court of Appeal stage or Supreme Court stage, they can still grant you an amendment, so long as you're not departing from the real essence of the original matter, and you're not distorting the evidence that's been laid at trial. You can still be granted an amendment. Of course, by way of application, you make an application for the amendment, and then you adduce reasons why the court should, allow you to amend. And if the court is so persuaded, they will grant it. Even if it's a non-consequential amendment, maybe you omitted a T, or you omitted to cross a T or dot an I, you can make it orally. You don't even need an application. And if the other party is not, averse to it, the court will grant it, and you can just go on with the case. Very important. An amendment is deemed as the original, pleadings. So if the original pleadings were filed in 2012, for instance, and you're making an amendment in 2013, it will the document will still be deemed as filed in 2012. So it doesn't mean that your case will now start all over from 2013, or when it's been referred to during judgment, the court will now say, we started this case, or when it's being referred to in judgment, the court will now say, we started this case in 2013. No, it will still be 2012. And also, when a party has filed an amendment, if you also now want to file an amendment necessitated by their own amendment, you can make an application for consequential amendment. So your own will be consequential amendment, that is amendment as a result of the amendment of the other party. So really, the court gives a lot of leeway for parties to regularize their processes before it and come correct, so that no injustice is done. But importantly, check the rules of the court where you are doing your matter. It will stipulate the time frames, because those are very important for amending these things, and times when you will not be allowed to amend, times when you will not be allowed to file again, the fees you have to pay, and all that. So in this video, we've talked about pleadings, we've talked about the types of pleadings, the content of pleadings, amendment of pleadings, and what have you. And it's important for you to also note that pleadings are a set of material facts in support of your claim before the court, and your claim itself, and then the defense too, or the counterclaim, or whatever it is you're filing in response to what is being filed. Those are parts of your originating processes. But the writ of summons or the originating summons is not pleadings. But when it's read alongside a statement of claim, then you can look at them as both. You can look at them both as pleadings. But on its own, a writ of summons is not pleadings. And whatever is mentioned or made reference to in a writ of summons should be contained in your pleadings as well, else it's deemed abandoned. Also note that you cannot lead evidence contrary to your pleadings. Whatever you plead must be laid in evidence. And if you're leading evidence and it's not already in your pleadings, The court will not allow you. The other party would even object while you're introducing new facts. So you must contain everything you want to talk about at trial in your pleadings. And at trial, you must talk about everything that you put in your pleadings. So it's a two-way traffic. Very important. Also, if time elapses within which you're supposed to file, it's not a sorry situation. You can always file for extension of time and then pay the fees and then file your processes, your pleadings. Lastly, where there's motion for judgment in default of pleadings and you have brought a motion for extension of time for you to file the pleadings as the party that refused to file for so long, the court will consider your motion first before the motion for judgment. So you will still be allowed to file because the court really wants audi alteram partem to take place. That is, both parties should be heard before it makes a decision. So that's all I have for you in this video on pleadings. I hope you watched till this point. If you did, thank you so much and congratulations for doing yourself a huge favor. I will always see you in my very next video. Toodles.